This is Terrell Williams?
Yes, sir.
All right. So we're on the record in docket 22-03-000. That's people of the state of Michigan versus Terrell Williams. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Please the court, Deputy Chief Public Defender Steve Cornish on behalf of Mr. Williams, who's in the court and standing to my right. Mr. Williams, would you please state and spell your name for the record?
Terrell Williams, Terrille. Last name Williams, Williams.
All right, thank you, sir. Mr. Pfeiffer, this is the time set for preliminary examination. How we proceed?
Your Honor, the people are requesting an adjournment today. Yesterday, the people discovered that the defendant has been communicating with the victim from jail and instructing her on what to do, not do, and what to say in order to get this case dismissed. He has over 80 calls, over a dozen e-messages, and either 4 or 5 video visits. They also use multiple fake names and accounts in order to evade detection. But particularly thanks to the video visits, it is clear as day that it is the defendant speaking with the victim. I compared not only with the body-worn camera, but also, as about 5 minutes ago, sorry, 2 minutes ago, I learned that not only is the victim here, she tried walking into the courtroom at the defendant's instruction, as the defendant, while being brought up, apparently told her to follow him into the courtroom. And it is very clearly her in the video visits under that fake name. He has instructed her to say it wasn't him, that it was somebody else. And also to never come to court, even if his attorney tells her to come to court. As a result of this, Your Honor, the people need additional time for this to be investigated before any testimony can take place. And I would ask for that adjournment request to be granted.
All right, thank you. Mr. Cornish?
I thank you, Your Honor. I guess I'd point out right off the bat, we're here for preliminary examination, and the complaining witness is at the courthouse. And I'm certain the court is aware, Mr. Pfeiffer's aware, of how rare that occasion actually is. He'd like to now adjourn that, allowing for an opportunity for her not to show back up so that he can turn around later and accuse us of forfeiture by wrongdoing, which he alluded to just a minute ago. Despite any allegations he made against my client in regards to telling her not to appear or telling her not to show up even if I tell her to as his attorney, she's actually here, Judge, and prepared to proceed this morning and testify. It's my understanding that there's been email communications to the prosecutor's office directly to Mr. Pfeiffer, I believe, in regards to possibly recanting these allegations. I know that somebody at my office also received an email, not me, that may have been forwarded to me. I have to go back through and look for it. And honestly, with her being here, I don't see why we don't take half an hour or so to begin this exam so that we can at least preserve her testimony. So that in the future, that could be used at future proceedings. It seems wild that we'd release her knowing that she may or may not ever show back up.
Thank you. Response, Mr. Pfeiffer?
Yeah, I did that about a month ago with Judge Simmons, and the way that it worked was I discovered evidence that the defendant had been telling her what to say at court. I brought this to the court. We held the examination. We then stopped it after the cross-examination so that people would have time to go through these jail calls of the instructions that were given to the victim of what to say in court so they could properly impeach the victim. And then the victim never appeared again because she was able to testify as the defendant wished her to and get out what the defendant wished her to do. So, Your Honor, that is what I'm seeking to prevent here. I've only listened to 2 of the 80 calls. He instructed her what to say to the prosecutors, that it wasn't him, that it was somebody else, which also flies in the face of what she told officers in the police reports. As a result of this, Your Honor, an adjournment is necessary in order to ensure that the testimony that is given is not only accurate, but that the people have the proper chance to actually impeach the victim if that is what's to take place. Just is their right to do. She's here once, she'll be here again.
Mr. Cornish?
Judge, I know it's his motion. I obviously let him have the last word, Your Honor. Up to you, of course. That having been said, this is a unique case, and I wasn't going to bring up the police report. But in the original police report on the date and time of the incident, or near the date and time of the incident, she never actually named my client, Your Honor. She named a different person. She described that person, gave the police officer that person's general location and whereabouts. It was only much later, a week or more later, on a brief phone call with the police, that she sort of flip-flopped her story, named my client briefly, and then never contacted the police again, as though she was scared of the original person that she identified as being the perpetrator of these crimes. So this whole she's being told what to say, I don't know. I haven't had a chance to review these calls. But if we're going to bring the police report into this, my client is about 3 sentences in a police report versus multiple paragraphs in regards to the, or at least one big paragraph in regards to this other individual to whom was named in the original complaint to the police on the date or near the date of the incident. While it was fresh in mind, I think she might even still been in the hospital recovering. So it's highly relevant to get this testimony out about this other gentleman.
Mr. Pfeiffer, last response.
Yeah, I'll quote Mr. Cornish just now. I don't know what's in these calls because I haven't had a chance to review them. That's why the adjournment's necessary, Your Honor, for the chance to review them. Eyewitnesses said that it was the defendant who did it. The victim eventually told Detective Pete Skaish that it was the defendant who did it. And then the defendant tells her in a jail call, say it wasn't me.
All right, so I've heard the argument in this case and a request for an adjournment for good. I would treat this as a good cause adjournment, not having the defendant waive any rights. The two things are first and foremost to the court's concern. One is that an assault murder has been issued with the alternative counts of assault, GBH, felony assault. Those are all serious crimes. This is a fourth offense notice, so there's a mandatory 25-year just on that in regards to this. So, I mean, the matters aren't to be treated and are not being treated with any type of with any pretty serious matters, and everybody's treating as such. The court's further main concern is a PA 53 violation, no contact order violation. The no contact order was signed by myself on April 27, 2023. And there's an allegation now that the defendant has violated not only that contact, but multiple violations of that no contact order. So there are immense discovery issues here. Mr. Cornish has indicated he's got to review those. Mr. Pfeiffer's got to review those. We could have multiple witness tampering or things of that nature, not to mention a PA 53 no contact and multiple events coming from there. And so it kind of is not unusual. It's not the usual case in which a victim appears when there's been at least 2, for the record, contacts from the defendant to the victim, and then there's multiple discovery issues that still needs to be done. So with the adjourned for PA 53 violation, discovery issues, and the potential for new charges, I will grant the adjournment. For good cause. The defendant's not waiving any of his rights today, other than the fact that he's incarcerated and the case will be adjourned. So a new date for the preliminary examination. I
actually gave them 3 days before we took the bench. They have settled on June 5th.
Okay. June 5th.
Monday.
Perfect. June 5th at 9:30. And we'll come back here and we'll do the preliminary examination on that date. That's a Monday, so it has its own date and time. Anything else for the record, docket 220300, Mr. Pfeiffer?
2 things. First, I'd ask that the court instruct the defendant not to speak to the victim while he's being brought through the hallways, as he did when he was brought into the courtroom. And then secondly, I would ask that the defendant's jail privileges, particularly phones, e-message, and video visits, be taken away because of these contacts. And if a proffer is needed, I can provide a proffer showing her face in the video visit with him.
All right, Mr. Cornish, any comment on that?
A moment, Your Honor.
Okay. Yes. You know what I mean?
I do not.
You know, I mean, for the person whose name it is, I know who that person is. So for contact, we stay with somebody else to come. You know what I mean? I don't have no control of that.
He's taking over phone privileges. I'm suspending phone privileges until
me like, I didn't say, like, come visit me or anything like anything. It's the same what I said. I never just said anything, and then like part of it just paper. See the other guy on the screen last week. He showed, like, even prior to that, he showed me when he came to see me on court that he showed me what was sent in already to the prosecutor before, like, okay. So I didn't know. And then I was trying to figure out, like, prior to giving something months prior. This was what's and that's what happened. It was never a completed visit. It hung up. You know what I'm saying?
Your Honor, I guess what I would request is that it appears Ms. Johnson is actually here. I'd request she get a copy of the notice to appear, that she's informed that her subpoena would be continued to that date so that she appears
I think that's fair.
today before we leave.
People have no problem with that whatsoever.
So I think that two things that'll come out of this order. One is the continued no contact with the victim. She'll be notified of the preliminary examination. She'll be given a subpoena. She's under subpoena. She violates that subpoena, it's a problem. Mr. Pfeiffer can take care of that witness. I will continue a no contact order as always. But if it's initiated, any contact initiated by the defendant, it's going to be a P53 violation. Any contact initiated by the complaining victim in this case, we'll leave it up to Mr. Pfeiffer to.
It's almost not possible for her to initiate it
Right.
because he has to like initiate the video visits and the jail calls.
I'm only talking about the hallway.
Oh,
Yeah.
okay. I'm actually gonna go out first and
Right.
go talk to her and get her information.
So the hallway, the 54A District Court hallway, I'm more concerned that I don't want to blame the defendant for her coming up to him, but you should not have any your continued no contact. Jail, because in the interim, we have contact between the victim and the defendant. For our purposes, jail privileges are suspended, all right? Except as to the attorney visits, of course, anything constitutional. And then we'll revisit that issue at the preliminary examination, all right? Anything else for the record, docket 22030000, Mr. Pfeiffer?
No, Your Honor.
Anything else, Mr. Coleman?
And for the record, I will go hand her her notice to appear.
Okay, thank you.
Thank you, Nancy.
I'm assuming.
Nothing.
All right, thank you, Mr. Cornish.
Thank you.
Favor. Thank you, Mr. Cornish.
Thank you, Your Honor.
No, yeah, I meant here. You don't have anything else?
Mr. Stevens, you're gonna go out there and make sure they're not too loud?
No, Chuck. I don't have the authority to do that.
Shoot.
I want to try and get some stuff moving.
All
Oh,
right.
you are doing something?
Nope.
I thought I
Get
tripped.
your.
I took my spot in
almost
line.
Used the naughty word, get your rear end in here. Yep. Don't step on that, you'll get
That's
stuck
good.
forever.
Unfortunately, we can't have anybody in the gallery due to,
How many do you want in here? Because I can probably line up another waiver if we can just.
we're just gonna bring them in. The
Just bring it as
defendant
they
and
come.
attorney.
Yeah.
Yeah, one by one.
Oh, shoot.
It's kind of
Probably
a,
need my computer. I'm so sorry.
it's a thing.
Right.
I'm so sorry.
we'll have another waiver after this, Sims.
All right,
Okay.
so are we ready on Davis?
Yeah,
Aaron,
Ms. Housefield's coming
All
in
right.
to do it.
All right.
Yes, I just have the wrong file in my hand, so that's the problem.
Morning, Your Honor. Good morning, Mr. Abbott.
Yeah, unfortunately, we won't be able to have anybody answer.
Too many people cause me anxiety. I don't like all this.
Look,
I don't like all the
we've had
stakeholders
this,
out there.
we've had this talk about your heart.
Yes, I know. Last week, I come in with a new heart issue every week.
Yes, I feel.
There's nothing we can do about the
Yeah.
benches, so,
Hey, at
Oh,
least
yeah,
you know.
hey, we're in our own room, so that's.
yeah, that's fair.
I was in Judge Simmons' courtroom for landlord tenant, and I think it changed some of my rulings, I'm not sure.
I actually I was sort of excited to see you and Judge Ward do like a tag team swap out.
Not, evidently not gonna happen.
No.
Let it go, Ian.
Sorry, I have my
Oh,
phone to say the opposite.
All right, so we are on the record in docket 23-01113. That's people of the state of Michigan versus Michael Davis. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. John Abbott representing Michael Davis. He's present, standing to my right.
And sir, you are Michael Davis II?
Yes, Michael
Okay.
DeBar Davis II.
Thank you.
Yes, Your Honor.
This is the time set for preliminary examination. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant wishes to enter into an unconditional waiver to circuit court. The people would also unconditionally waive their right to hold the preliminary examination and ask that the matter be bound over on the complaint as filed. I have an offer that I can place on the record.
All right.
The offer is for the defendant to plead as charged to counts 1, 2, and 3 with a reduction of, with the habitual offender second offense notice remaining, but a killabrew of a county cap and a dismissal of counts 4, 5, 6, 7, 8, and 9.
County, and then I'll just place it on the record, a dismissal of, is that counts 2 through 9 or
4 through 9, Your
4
Honor.
through 9?
Yes,
Okay.
that is correct.
All right. And Mr. Abbott, that's your understanding of the negotiations as they are today. Counts 1, 2, and 3 habitual extended is a part of that. Killabrew to county dismissed 4 through 9. And I'm assuming negotiations or talks will continue in circuit court.
That's my understanding, Your Honor.
All right. May I inquire your client of his waiver?
Yes,
All right. Mr. Davis, you understand you have a right to preliminary examination within a timeline, timeline of your date of arraignment. You understand that, and you waived that timeline on April 20th, and so you have a right to preliminary examination in front of the court. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Ms. Housefield would do that today. Mr. Abbott would be here to contest any charges and cross-examine any witnesses brought against you. You understand that? My understanding, it is your intent to waive your right to a preliminary examination today. The offer's been stated on the record and negotiations will continue in circuit court.
Yes, Your Honor.
Is it your intent to waive your right to a preliminary examination today?
Yes, Your Honor.
And the people also waive their right, I'm assuming.
Unconditionally, yes.
All
Your Honor.
right.
Thank you.
I find the waiver of the preliminary examination be knowing, voluntarily, and accurately made. And we will, you'll get your next date. So you're done here in district court. You'll get your next date from Mr. Abbott in circuit court. And I'll have you sign a waiver bind over to that effect. All right. Mr. Abbott, I'll have you. I'm not sure if that's a place for you to sign or not. I should have looked.
Your new form has it, yeah.
Form?
Come on in. You guys have Zoom up, Wendy?
We do.
Yeah, it's up.
Is there anybody in for you? Mr. Hess is trying to locate,
Maurice Bell.
but maybe he was in on Ward's Zoom.
We didn't tell anybody.
All right, so
We just found out. Yeah, we've been.
okay.
We don't have anybody on Zoom. Zoom is up.
Luke, don't break it.
Thanks, John. Appreciate you stepping in.
I was just making sure that wasn't.
Slide over. Trying to get it in. Okay, that guy shows up in 5 minutes. Okay. That would be a bad thing. Yeah.
It's yeah,
It's just.
I like it.
Hey, I'm
I wouldn't
happy.
do it every time.
No, I'm happy.
Yeah,
I'm in
I
my
got a
own
bunch
room.
of officers here for years.
Yeah.
Mr. Goodrich, you ready on Ms. Sims?
Yes.
All right. Right, so we're on the record in docket 22-03343, People of the State of Michigan versus Monique Sims. Will the parties please introduce themselves to the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office here to represent Ms. Sims, who's standing to my right.
And ma'am, you are Monique Sims? All right, this is the time set for preliminary examination today. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have made an offer, and that would be for, is for the defendant to waive the exam and then to accept an offer to plead guilty to count 1, OWI causing serious injury, at which, up in circuit court, at which time the people would dismiss counts 2 through 4.
Okay, so there's an offer to waive the exam and plead to count 1. What were the other terms of that? Plead to count 1?
And then the people would dismiss counts 2 through 4.
For in circuit court. And Mr. Goodrich, is that your understanding of the plea offer at this time is to plead to count 1, dismiss counts 2 through 4, and waive the examination as is?
Yes, it is.
All right. So the offer is placed on the record. It's a bound over as charged, but a waiver of the preliminary examination would solidify plea to count 1, dismiss counts 2 through 4.
Right.
And Ms. Sims, that's your understanding of the offer as you heard the lawyers talk about it?
Yes.
Okay. You understand, ma'am, that you have a right to preliminary examination within a 21-day timeline of your date of arraignment. Do you understand that? A preliminary examination is what we're here for today. Mr. Brodowitz would bring in witnesses, and Mr. Goodrich would cross-examine those witnesses and contest any charges brought against you. Do you understand that?
Yes.
The standard for preliminary examination is probable cause. So the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that?
Yes.
So with that understanding, is it your wish to waive your right to a preliminary examination today? The time will be done in district court and you'll go to circuit court where the case will continue as indicated in the plea offer.
I'm sorry, I didn't understand.
All right, yeah, I barely understood it myself,
We're
okay?
gonna be done with Judge Flores in the district court, and the case is just going to move to the circuit court, where matters will continue there.
Right.
Okay.
So you're waiving your right to a preliminary examination, you're going on to circuit court.
Yeah.
All right. I find that the preliminary examination to be knowing, voluntarily, and accurately made. Mr. Brodowitz, you're also waiving your right to preliminary
Yes, Your
examination? All right. And I'll bind over as charged with the understanding that the offer's been made for the record. And I will sign, I'll sign a bind over to that effect. There should be. Yep, there's one for the prosecuting attorney. So here's the paperwork. So keep in contact with Mr. Goodrich. You'll get your next date in circuit court from Mr. Goodrich. Okay, ma'am?
Yeah.
No. Yep.
Oh, you have a different address?
You can amend it for the record.
Yeah, could she tell the court her new address? Would that-
Yes, yes.
Oh, you'll need to file those.
That's what I can take. What's your new address?
It's 2520 Wood Street,
2520 Wood Street.
apartment 7, Lansing, Michigan, 48912.
48912. Okay. All right, so I'll sign the waiver and then I will make the update to the address.
It's already.
All right.
I
All right, anything else for the record in docket 22-03343, Mr. Brodowitz?
Nothing for the people, Your Honor.
Mr. Goodrich?
No, Your Honor, thank you.
You're all set, Ms. Sims. Thank you for your appearance today.
Thank you.
Your Honor.
Since Mr. Carter's in here. Okay. Do Mr. Ayers next.
It's up to you.
I mean,
Do you want? Not here.
yeah, let me see if the note, let's see if the notes.
All right, let me know.
Okay. Just wait here, Mr. Carter. If notes isn't available, I can be on there. All right.
So it's Ayers, and how are you, Mr. Carter?
Do you have my substitute?
I do.
I got an email from the public defender's office that I need to forward them a copy.
Johnson.
All right, well, looks like we're doing Brown and Bell.
Okay, so you want to do Bell and Brown?
Brown and Bell, yes.
Okay. You were here on Ayers.
I can resend it to the public defender's office. I sent it.
Yeah.
Oh, you signed it.
I have it. We'll resend it to him.
Are you sure? I don't want to put any.
No, I'll resend it, Mr. Carter. I always send it to him after judge signs them. They may have just.
Okay, thank you. I
Yeah.
appreciate that.
Thank you,
I'll
Mr.
take care of
Carter.
that, Mr. Carter. Not a problem.
All right, so we have. So we're doing Bell and Brown together as co-defendants. We're on the record in 23-01212 and 23-0210. That's people of the state of Michigan versus Maurice Bell, and people of the state of Michigan versus Tyrazis Brown. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Morning, Benjamin Hall, appearing on behalf of Mr. Brown, who's present standing.
Okay, so Mr. Hall, you're here on Mr. Brown. How are you, Mr. Hall?
Doing well, Judge, yourself?
Good.
Good morning, Your Honor. Edward Hess on behalf of Maurice Bell III. I'm not aware of Mr. Bell's whereabouts. I will state for the record that Mr. Bell did appear last week by Zoom.
Okay.
And after that, I attempted to contact him. I left a voicemail with an individual, or I'm sorry, not a voicemail, a message with the individual answering his phone number. This individual said that she would have Mr. Bell contact me. I've not heard from him since. However, since he was diligent about coming last week, I hope that if the court does grant the forthcoming adjournment request, that I will be able to get in touch with Mr. Bell and have him catch up as to his next court date.
All right, and my understanding, so let's start with Mr. Bell. It was scheduled for 8:30, it's now 10:01. We have had some disruption in the court, as you know. Mr. Hess did, and I'm assuming you checked with Judge Ward's courtroom and Mr. Bell was not there.
That is correct. He was not there in person, and nobody by the name Maurice Bell was logged on to the judge's Zoom. In fact, nobody was logged on to her Zoom at all.
Okay.
I did hear from somebody in the hallway that Mr. Bell may have been spotted logging on to Judge Ward's Zoom, but nobody down there had any recollection of that.
All right, Mr. Brodowitz, in regards to Mr. Bell, we have a failed to appear. How do you want to proceed?
I guess at this point, Your Honor, the people would ask that a bench warrant be issued and any bond be forfeited for the failure to appear.
I indicated to Mr. Bell that the preliminary examination is live in person. I had that in quotes from the probable cause conference. I'm going to indicate that the bench warrant and bond forfeiture be issued at this time. Because of the probable cause conference and the indication that to be live in person, we're about an hour and a half. I know we've had some disruptions. Also, I will indicate for the record, the charges here are all CCWs and all gun related. If you're able to get a hold of Mr. Bell, let my staff know and we'll get him in here and make sure that he understands the examination date. And we can revisit this, but at this point in time, I'm going to issue a bench warrant bond forfeiture.
Understood, Your Honor.
All right. And then as to Mr. Brown, Mr. Brodowitz, how are you proceeding today?
Well, it was the plan on this, Your Honor, because this is a co-defendant case. Have been some discovery issues in this matter, being as I don't believe either of the defense attorneys has any, if not all of the discovery. So the people would be asking for an adjournment of this matter in order to sort out the discovery issues and be able to hold this examination as one, or these examinations as one examination.
It's problematic because we don't know about Mr. Bell, so we don't know. But as in regards to, and Mr. Brown did show up, but we initially bench warranted him from last week. Then he showed up at 2 and we struck the bench warrant. Mr. Hall, how did you want to proceed on this? I'm assuming you share that you don't have full discovery on this.
That's correct. And just for the record, I've received a police report, but there is video discovery mentioned in the police report, surveillance video, as well as body camera and NPR. The discovery that was sent to myself, and I don't know about Mr. Hess, but the discovery that was purported to be belonging to this case does not in fact belong to this case. So there's a miscommunication or error that is being rectified. But I've spoken about this with Mr. Brown. I think we need to waive the 21 days and adjourn, and we will be proceeding to the preliminary examination.
All right. All right. So may I inquire your client of his 21-day or the timeline rule?
Yes, sir.
All right. Mr. Brown, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that? All right. So it's actually, I think, 14 days or 14 days from your probable cause conference, but it's a timeline that puts it within 21 days. With that understanding, because of the lack of discovery that we've had in this case, and you want your attorney to be fully compliant with having all the discovery so he can zealously advocate for you. You know that preliminary examination is a probable cause hearing in which preliminary examination, the standard is preliminary examination, and Mr. Brodowitz would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You understand that?
Sure.
You of course have Mr. Hall here who would cross-examine any witness and contest any charges brought against you. Do you understand that? Sure. Right now, the people are asking for adjournment for discovery issues. Mr. Hall would like the discovery before he has to cross-examine any witnesses or contest any charges. It's my understanding you wish to waive your right to preliminary examination only within that 21-day period, not in general, just within that 21-day period. Is that correct? Sure. Are the people also waiving their right to a prelim within 21 days?
We are, Your Honor.
Okay, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset this prelim May 25th at 9 a.m.
I'm in a trial at that time in Shiawassee County.
All right, let's reset that then.
June 8th at 8:30.
June 8th at 8:30.
I am in Gratiot County. If the 25th, I don't think it's gonna go, but I won't know until I think that Monday. So if that, on that Monday, if it is gonna go.
All right,
Okay.
let's do the May 25th date, and then we'll wait to hear from you, Mr. Hall.
That was
At 9 a.m. And so I would suspect that if it is going, Mr. Brodowitz, have your witnesses here. And I think at this point in time with Mr. Bell, we'll just have to act as if you may have to call him twice, depending on Mr. Bell's whereabouts, okay?
Yes, sir.
All right. Anything else for the record in docket 23-01210? That is Mr. Brown's case.
And nothing from the people. Your Honor.
Anything, Mr. Hall, on Mr. Brown?
No, Your Honor.
And anything else on docket 23-01212, Mr. Hess, concerning Mr. Bell?
Nothing further, Your Honor. I will do my best to get in touch with you.
All right. That's all for the record about those files. Thank you.
Thank you. Substitutions work out as far as sign.
Yes. My assistant.
It's Ben, if you don't do anything, then a day or two, let me know. I'll make sure you get on your stuff.
That's it.
Cool.
Nope.
The jail. Yeah, so, well, Carter, get you up. We'll get him on. Yeah, thanks, Ben. Like I said, if you don't get what you need, let me know. I'll make sure we get that. Yeah. Don't Don't step on it. You get stuck here forever.
Flores made it lovely.
Get him in here.
Guys done.
That's your sheet. There's not enough orange on it, yeah. Just a- Leave this dude here.
He should be. There's a writ for him.
Oh, is he?
How you doing, Judge?
Good, how are you, Nick?
For Jackson County writ.
Oh, he's in custody?
Yeah.
Oh, okay.
She said she had a flat tire. She was gonna be here in 10 to
She
15
showed
minutes.
up.
Okay.
Mr. Abbott couldn't remember the name.
And then he's in custody too, right?
Yep, it's downstairs.
That's probably.
I thought you should step over here.
I'm serious move there.
Yeah, you just love it, so.
Unless you want to stay.
No worries.
I mean, you can't retaliate against him.
Even
Even that one caught the judge's attention.
He was wondering what I was
Wow.
going to say.
Wow. I don't think I've ever heard that out loud.
Judge Mr. Stevens is being difficult.
I think he's being funny.
I'm here for Justin's, I'm his mother. Is that right?
It's only because we're getting our courtroom redone, so.
Okay. All right, that's okay. We'll be right here for you.
All right, so we're on the record in docket 23-00776. That's people of the state of Michigan versus Justin Michael Ayers.
I think we need a prosecutor.
Oh, we do. Well said, Mr. Carter.
I'll go get him.
He's making one more lap.
All
to
right,
make sure
all
his
right.
Witnesses aren't here.
I'm just thinking right now. If we have to
I
run
think
a
that's
pre-
good.
We have to run a prelim. Only doing that every like 20 minutes or so, we just may have to pause.
All right.
All right.
All right, Mr. Brodowitz. So we're on the record in docket 23-00776. That's people of the state of Michigan versus Justin M. Ayers. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
May it please the court, David B. Carter Jr. on behalf of Mr. Ayers, who is present, standing at council table.
And sir, you are Justin Ayers?
Yes, sir.
All right. This is the time set for a preliminary examination. Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor, as you stated, today's a date and time set for a preliminary examination. This matter was set at 9:30. It is now 10:11. The people have subpoenaed witnesses. I've called, the hallway as the courtroom is out of service. And it appears that those witnesses have not appeared, so the people would be unable to proceed at this time.
Mr. Carter.
Thank you, Your Honor. Normally, I would allow an adjournment. However, we did this once before and the witness didn't show up. So there's a point in time where my client needs to move on from this. So we'd ask for a dismissal. I'll explain to my client that is without.
All right, thank you. I will indicate for the record that we initially were here on May 24th. There was adjournment. Mr. Carter was a conflict counsel, came in substitution of counsel on April 20th. We adjourned this matter because the witnesses had not appeared yet. And so there was some interest in contacting them. We've now set it for May 4th. It would appear the witnesses have failed to appear. This was scheduled for 9:30. It's now 11 o'clock, as the prosecutor said. There's been, the witnesses were subpoenaed to be here. And with that understanding, I will grant the motion to dismiss by the defendant. And as you'll hear from Mr. Carter, that's without prejudice. So the people could reissue if they choose to, but for our purposes, the case is dismissed today. Okay, sir?
Yes, Your Honor.
All right. Any questions? Any questions concerning 23-00776, Mr. Brodowitz?
Nothing from the people. Your
Anything,
Honor.
Mr. Carter?
No, Your Honor.
Okay, you're all set. Good luck to you, Mr. Ayers.
Thank you.
Thank you.
All of those on that case, so
All right.
you can only put 1 through 3 on a, and then you have to do it count by count.
Okay.
I always forget to check.
Yeah, thanks.
Wendy, what date did we set, or did you set Bobby Harris for the review? Or did we? not?
Sometime in June.
Okay,
Hang on, I'll look it up.
That was Harris.
yeah. Hey. I gotta give him a few minutes to get downstairs. I will say I wasn't entirely truthful on the record, but,
7/27.
okay, 7/27, thank
Yeah,
you.
we have to we always give, the first time we send somebody to forensic, it's a 90-day review day.
Yeah.
They're close enough to what the doc will allow.
I just wanted to know what to put in our file.
Yeah, and then we will figure all that out once we get the report, because we held all of his cases.
I will say I wasn't misspeaking when I said that I can't proceed at this time. It's just, I did have one witness here, but he informed he's sitting down. That, we're off right now, right? Muted?
We're up.
Judge, if I may,
Yes.
Miss Bree Scott's behind me.
Oh,
Oh, there we go. All right.
Okay.
Oh, geez. Okay, I was looking for you. Hi, sorry, guys.
Well, you saved yourself a bench warrant, Miss Scott.
Yeah, thank God, because the coffee wasn't worth it.
Nice.
I like coffee, but not that much. Thank you, Your Honor, for not doing that.
Well,
I think Andrew
I
cut
did
the
it, but we can undo it
your
fairly
job in the
quickly.
thing.
Oh, thank God, because I don't want to do that again. I don't like jail.
All right. So we're on the record in docket 22-01695 and 23-00942. We previously issued a bench warrant for failure to appear on both files. Ms. Scott has appeared today, so we're going to strike that and start from scratch. Mr. Brodowitz, we have two files today. There are two different files. How are we proceeding today?
At this time, Your Honor, I guess I will start with the oldest one, which would be 22-1695 FY. As you stated, today's the date and time set for preliminary exam. The people have subpoenaed witnesses. Those witnesses have failed to appear, so the people are unable to proceed at this time, so I would leave it to the defense.
All right, people are unable to proceed. Witnesses fail to appear. Subpoenaed. Mr. Abbott.
Move to dismiss, Your Honor.
So the motion to dismiss is granted as to file 22-01695. I'll wait the Nolly I'll send the Nolly Plus on that. So it's dismissed without prejudice, Miss Scott, which means they could reissue if they choose to, but for our purposes today, the case is dismissed. All right, ma'am?
Yes, yes, Your Honor. Thank you.
All right. And then we're on the record in docket 23-00942, People of the State of Michigan versus Bree Scott. And on that file, Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. As you stated, today's the date and time set for preliminary exam. People have subpoenaed witnesses. One of those witnesses has appeared, so the people would be ready to proceed at least in part on that preliminary examination.
Mr. Abbott, are you ready? Are we ready to go on one witness?
Yes.
All right. So are there any preliminary matters other than sequestration, and we've constructively sequestered the place because we're getting new benches? Anything else that could come to the court's attention, Mr. Brodowitz?
Nothing from the people, Your Honor.
All right. Anything, Mr. Abbott?
No, thank you.
All right. Mr. Brodowitz, you may call your first witness.
All right, Your Honor. The people would call Detention Officer Tasia Thieber.
All right. Mr. Ring, how are you?
Yes, good. How are you?
Good.
Yeah, me too. Jeez, you know how busy it was over there? Everybody's there getting coffee.
Is it okay if I sit over here in the jury book?
Absolutely. All right. So, Ms. Tebert, you can have, and you're a DO, right?
Yes.
All right. Come right here. Please state your name and spell your first name and your last name for the record.
Tasia Thieber, TAYSHIATHEIBERT.
All right. Please raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. Have a seat here and project for recording purposes into the microphone. We may occasionally get noise from the other courtroom, so just do your best, okay? All right. And I'll have you project for recording purposes just over the noise. Mr. Brodowitz, you may proceed.
All right. Good morning, Ms. Thieber.
Good morning.
Apologies for the wait. Ms. Thieber, how are you employed?
By the city of Lansing.
In what capacity?
Officer.
And what specifically do you do for the city of Lansing? As an officer?
The detention, sir.
Okay. And what exactly is a detention officer?
We maintain the inmates, we keep an eye on them, make sure their welfare is good. We put them in, we search them.
Okay. And were you working in that capacity on March 21st, 2023?
Yes.
And on that date, was an individual by the name of Bree Scott brought to LPD lockup. Did you personally check in Miss Scott? Do you see Miss Scott anywhere in the courtroom today? Okay. Can you please indicate where she is sitting and an article of clothing she's wearing?
I believe she's sitting right in front of me wearing white.
Please let the record reflect that the witness has identified the defendant.
Any objection for preliminary examination purposes, Mr. Abbott?
Not at this point.
All right. Without objection, the witness has identified the defendant.
So when Miss Scott was brought into LPD lockup, how did you proceed?
I believe I booked her in, and then I proceeded to go and search her. I informed her that she'd be searched twice, once with cuffs on, once with cuffs off. And then proceeded by checking her left side. As I got to the first pocket on her coat, I put my right hand in, and I pulled out a little glass bottle of some sort that was containing methamphetamine.
So you pulled out and how, yeah. Did you personally test the substance of that vial?
No, I did not. It was given to the officer. He tested it.
Okay, and so that would just be from your
From
your
my
observation.
experience, yes.
That's okay. And did you find anything else on Miss Scott?
No.
Okay. And then after you finished the search of Miss Scott, what happened?
She was taken back to the cell.
No further questions at this time, Your Honor.
Any questions, Mr. Abbott?
Good morning. So I noticed when he asked you if you saw Miss Scott, you kind of scanned the room.
Yes.
And I think the words were, I believe that's her. Is that because you're not certain that this is Miss Scott, or you're not certain this is the person?
It had just been a minute. It's Miss Scott.
You're confident that it is?
Yes.
And as far as the stuff that you found in her pocket, you're claiming it's in a glass vial or a glass bottle?
It looked to be in an old makeup container almost. I don't know how much you know about makeup, but there's an eyebrow thing. It's normally a glass bottom and has a black top. And when you empty it out, it's a perfect little circle that you could maintain. You can keep a lot of different things in it.
So it was a makeup container, you think?
I think. I don't know for sure. Doing anything.
All right. And you didn't test it yourself?
No.
So you have no personal knowledge of what it actually was?
I have the personal knowledge of what the doctor told me it was.
It's okay, you don't need to share that with us today. And what was she wearing? You remember?
I remember that it was found in a pink coat. I don't remember what else she was wearing. I just distinctly remember it was an old pink coat. It was a little beat up.
Was there anyone else searching at the same time?
No, it was on search.
Okay. And after you searched the pink coat, did you search the rest of it?
Yes.
Clothing? Find anything else? And you know where she came from? When you searched her, she was down on the third floor here in Lansing lockup?
Yes.
Okay. And do you know how long you know where she came from?
I believe she came from her own vehicle where she rear-ended, or not, yeah, she backed into a sheriff and then she was arrested and brought up to me. I don't know where that happened.
Do you know how long she had been in custody before she arrived? Do you know how many people had contact with her in between the time she was arrested and she arrived in
No.
And did she say anything to you about it?
She said it was an old coat.
Thank you. Nothing further than that.
Any redirect, Mr. Brodowitz?
Just briefly, Your Honor. Ms. Liebert, you said the search occurred at the LPD lockup, and that's located in the city of Lansing and Ingham County? Okay. No further questions, Your Honor.
All right, just for that Lansing lockup is on Michigan and Capitol. It's right here in the building.
Yes,
Okay.
120 West Michigan Ave, third floor.
All right. Anything else, Mr. Abbott?
After this one.
All right. May this witness be excused, Mr. Brodowitz?
Yes, Your Honor.
Mr. Abbott.
Yes.
All right. So witness is excused. Thank you for your appearance today. And and Mr. Brodowitz, you may call your next witness.
At this time, Your Honor, the people would seek a brief continuation of this matter in order to get Officer Michaela Fomby, who was the arresting officer in this matter. I think a week should be sufficient.
All right, that would be
Unless,
certainly the arresting officer is the one who did the test of the narcotic. Is that correct?
yeah, unless Mr.
All right, Mr. Abbott, any objection to the request for adjournment?
Oh.
Okay, it's up to
Get adjourned anyway. So.
All right, so we will adjourn the matter for a continuation of the prelim. This is Tasha T-Bird. We'll adjourn for a continuation. All right, and we'll adjourn it to May 25th at 8:30. So that should give you a couple weeks to get Miss.
I believe it's actually a Mr.
It's a Mr.
How to say that.
All right.
It's like Michael.
Okay, so Officer Mikhail Fomby is, we're indicating, Ms. Scott, so your next date here is May 25th at 8:30.
Yes, sir.
Be here on time at 8:30. You recognize the problem with getting late
Yes, sir.
is that everybody thinks you're not here and then we issue a bench
Well, I
warrant.
mean, I was here, but I went to get coffee because I
Right.
was late. So.
Everybody said you were here, so that's a good thing, right?
Yeah.
All right. Anything else for the record, on docket 23-00942, Mr. Brodowitz?
Nothing from the people. Your
Mr.
Honor.
Abbott? All right, thank you. We're all set.
I think this was the first time. Testify. If you look at me like I had 3 heads.
What's that?
I think this was the first time Officer Bieber had ever testified. Because she's
Fine.
well, I don't know if you saw her look when I asked her how she was employed. She looked at me like I had 3 heads. Like I was an idiot. So.
Mr. Mills, fine, Mr. Perry Johnson.
I don't know.
All right. Mr. Lincoln's incarcerated.
Yes, they should both be downstairs.
Oh, Mr. Perry Johnson should be downstairs too.
They did a red one in Jackson County.
Okay.
Oh, thank you.
Docket 23-00609. That is people of the state of Michigan versus Jesse Lincoln. Will the parties please introduce themselves for the record?
Jeff Braddock's on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Jesse Lincoln. He's seated to my right.
And sir, you are Jesse Lincoln?
Yes, sir.
All right, thank you. This is the time set for preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have subpoenaed witnesses. Those witnesses have appeared, and so the people are ready to proceed with preliminary examination.
All right, are there any preliminary matters to come to the court's attention before we get started from the people?
Nothing from the people, Your Honor.
Mr. Abbott?
Nothing.
All right. And we don't have a sequestration problem. Just let me know if anybody comes in. There's no place to sit. So, I mean, that's obvious. Mr. Brodowitz, you may call your first witness.
All right, Your Honor, the people would call, I believe it's pronounced Zane Knockhazel.
All right, sir, you come up here. I'm gonna have you face me. I'm gonna have you state your full name and spell your last name for the record.
Zane Edward Nahazel,
Okay,
Nachazel.
and Zane is Z-A-N-E?
Yes, sir.
All right, thank you. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, please have a seat and project for recording purposes. Mr. Brodowitz, you may proceed.
Good morning, Mr. Is it Knockhazel?
Nahazel.
Nahazel, okay. Good morning, Mr. Nahazel. Sorry for the long wait. Mr. Nahazel, how are you employed?
Manager of Solden's.
And what, I know there are several locations. What Solden's Pet Store is that?
South Lansing location.
And what is the address of that location?
5016 South Martin Luther King Boulevard.
And that's located in the city of Lansing?
Yes, sir.
In Ingham County?
Yep.
Okay. And were you working in that capacity on or about November 5th, 2022?
Yes, sir.
All right, and on that date, what do your duties include at Solden's Pets?
Ordering, helping customers, checking through cameras, inventory, doing bank paperwork, and dealing directly with our corporate management.
Okay, so you said doing bank paperwork. Would that include, what would that include?
Basically seeing like all the money that comes in, I have to count it, get it ready to take to the bank, any cash, any checks, go straight there, take it to the bank, drop it off myself.
Okay, and so on, I'm going to take you back into November 5th, 2022. You stated you were working that day. Was there anything unusual that happened on that date that you recall?
It's hard to remember exactly every day, but I'm assuming that was the day I had a bad check come through.
Okay. How were you alerted to that bad check?
I was sent an email and then called by our payroll department saying that.
Objection, Your Honor. Hearsay.
Right. Any information would be hearsay. The call itself is not, but any information may be hearsay.
This is just purely to show effect on the list.
All right, so it's not for substantive purposes, only to show what he did.
Yes.
All right. With that understanding, the objection's overruled.
So you received a call about a potentially bad check. What did you do with it?
I looked into the check itself, seeing what was purchased, and then I went through my security footage after I found out what time it was cashed, to find who cashed it.
Okay, and did you ever see a physical copy of that check?
Yes.
All right. I'm going to show you what has been labeled as People's Proposed Exhibit 1. Permission to approach, Your Honor.
Granted.
I'm going to ask you to take a look at that photo, Mr. Nahazel. Mr. Nahazel, do you recognize that photograph?
Yes.
And what is that photograph?
It's a photograph of a copy of the check that was written on the bad check.
So that is a copy of the bad check that you saw that was cashed on that date.
Yes, sir.
Okay, and what is the name of the individual written on that check?
Sherwin, Missouri.
Okay. And who was that check made out to?
Sold Flores.
Okay, and what is the date on that check?
11/5/22.
All right, and how much is that check made
Your
out?
Honor, he's testifying about something that's not in evidence.
Oh, sorry. My
Yeah,
apologies.
that's true. So,
People would move to admit people's proposed exhibit 1.
motion to omit People's Proposed Exhibit 1.
Your Honor, there's no foundation for this photograph of a photocopy of a check.
Mr. Brodowitz, I don't know, and correct me, did the witness indicate that this is a fair and accurate representation of the check?
Apologies, Your Honor. I believe in a roundabout way, but I will ask to.
All right, with that, with further foundation, the objection sustained.
Okay, so you stated that is the check, is that a fair and accurate representation of the check that you saw that day?
Yes, sir.
Okay, people would again move to admit People's Proposed Exhibit 1.
Any objection, Mr. Evans?
It's my understanding of his testimony that he received notice of this thing and that he actually never saw the check itself. He just has a photocopy.
I think he indicated that he actually saw the check at some point in time.
Yes, he indicated that, I believe the witness indicated that when he was notified, he saw a copy of the check. after he was notified.
That's my understanding, is that he saw
a copy of the check.
So assuming this isn't a best evidence rule or anything like that, the question is this a fair and accurate copy of the copy of the check he saw? I would think that's not the actual check.
Yes, Your Honor.
All right.
That is my objection, Your Honor.
Right.
There's no way he can know if the check that he received, it's a picture of two sides of a check. And there's no way that he can know whether the front side and the back side of the check is actually the front side and the back side of the check that was presented at the
Right,
store.
right. So I understand the objection. I think the objection goes to the weight of the credibility and the admissibility of it. So I'm going to allow the exhibit to come in and then we'll give it the due weight it deserves. So People's Exhibit 1 is admitted into evidence.
Okay, so I'll just go back over that now that it's been admitted. So what is that a picture of, Mr. Nahazel?
Of a check.
And what's the date on that check?
11/5/22.
And how much is that check made out for?
$633.76.
Okay, and who, I guess who's that check made out to?
Sultans.
All right, and who is what's the name on that check?
Sherwin, Missouri.
Okay, and who was that, I guess, check cashed with?
Huntington Bank.
Okay. All right, and so after you saw the copy of the check, you stated you went back and you reviewed security footage, correct?
Yes, sir.
Okay, and what did you see on that security footage?
Objection, Your Honor. Again, he's referring to a photograph that's not in evidence or a video that's not in evidence.
So the question is, it's not hearsay, because I don't want him testifying. You're indicating what did he observe on the video?
Yes, Your Honor.
All right, I'll allow. Objections overruled.
What did you observe? Well, I guess I'll rephrase it this way. I will say.
I would you may ask him about the video.
So Soldens, you said part of your responsibilities is reviewing security footage.
Yes.
And does Soldens keep that security footage in the regular course of business?
Yes.
Okay, and so you have the ability, and right. So proceeding from there. So when you received that, how did you proceed after you received notice of the check?
Good question.
Okay, so you stated you went back after you received notice of the check, you went back and you reviewed security footage, correct?
Yep.
Okay, and what did you see on that security footage?
I saw a gentleman with a cart full of miscellaneous items that didn't make sense of purchasing to me, and my cashier a check.
Again, Your Honor, I'm objecting that he's talking about the content of this video. It's not about the effect it had on Mr. Nahazel. It's about the content itself here.
Right. He can see, I think he can respond. I'm sorry.
My response would be, Your Honor, that it's not an out of court statement because it's a recording. It's not something anybody said, so he can testify to what he viewed on the video.
I think he can, I think he can testify to what he saw in the video and the course of the video. He can't testify to anything that was said on the video, but he can testify to what he saw in the video. I don't, is the video lost in this case?
That I am
Do
unsure.
we have the video? I guess,
I haven't seen
right. The video would actually be the best evidence, but this is secondary evidence, which is, I think, acceptable. I think that goes more to weight than anything.
If the court would allow me a minute, I can check and see if we, I do not recall it, but I can check and see if we have it.
I think the video would be preferable. Mr. Abbott would
It's
prefer.
essentially, I think, under 1002, and
Right.
those that follow there, if you're going to testify about the content of a photograph, you need the photograph
Right.
or a video.
It goes to, it definitely goes to the foundation concerning this. Mr. Brodowitz, do you have the video? I think that's the best evidence is the actual video than having somebody testify about the video.
If the court would grant me just a brief recess to.
Yeah, and if you can't provide the video today, we've started the prelim, we have some testimony. So we can adjourn for the video to be made an exhibit. I just don't know, you will know you would know better, or maybe your witness would know if the video is available.
Just 1 second. From that specific date, Your Honor, the people do not have that video.
All right, is the video available to the people?
That we would have to make a request for discovery in that matter.
All right, about the clerk who took the check, is the clerk available?
We have not subpoenaed that clerk, and it is my understanding from speaking with my witness that clerk no longer works at Solden's.
So it would be so the video would be what we would adjourn for.
Yes, Your Honor.
All right. So is there a request to adjourn for the video? I understand Mr. Abbott's contention here that the best evidence here is the video itself, not somebody testifying to what they saw in the video. And if that video is available for preliminary examination on an uttering and publishing, maybe we should adjourn for your purposes in order to get the video here.
Yes, Your Honor. If that's the best evidence, then the people would ask for an adjournment in order to recover that video.
All right, and the foundation for that video would be laid through the witness, since
Yes.
this witness is the one who. Mr. Abbott, I don't want to try your case for you, so you've objected to the People's Exhibit 1, but now we have testimony concerning the video, so I'll let you make a record.
Well, Your Honor, I think that the testimony about the content of the photograph under MRE 1002, the content of a writing, recording, and photograph, the original writing or photograph was required. And I think that that's, since he can't actually testify as to whether or not the video itself actually represents what was recorded on the video, because he wasn't there when it was recorded, he can't make a foundation for the video himself. And the video isn't here, so I don't think he should be able to testify about the contents.
I think an adjournment for the video to see the video, if the video exists, is preferable to the witness just testifying as to what they saw in the video. I do think that that would be very persuasive evidence, and so I'll grant the adjournment for the video and for the witness to come and testify concerning the video, since the witness is the one who does the investigation for Solden's. So we'll reset. We'll adjourn the prelim and reset for May 25th at 9:30. In order I think Mr. Abbott has a point. I think in order for that's conclusive evidence that the occurrence happened. We did that. Plaintiff's Exhibit 1 is the check itself, but we have, if there's evidence out there, and Mr. Abbott should get a chance to take a look at it for discovery purposes.
What was the date again, Your Honor?
So it'll be set for May 25th at 9:30. Anything else for the record, docket 23-00609, Mr. Brodowitz?
Nothing from the people, Your Honor.
Mr. Abbott.
Yes, Your Honor. Mr. Lincoln has got a case up in 30th Circuit Court, and the bond there is headed for a drug treatment program. And he's on bond there, and he can be released from custody to attend inpatient treatment. I'd ask that similarly this court modify its bond so that he be allowed to attend inpatient.
I will modify the bond to release for inpatient treatment only. For inpatient treatment only. No other modification. The reason I'm doing that is if you're inpatient, you should go to inpatient, start working on your struggles. But you have a failed to appear in front of this court on April 20th. And so that might be part of the same problem, but it's only a modification to leave and come back, all right? So to go there and come back and that's the only modification for inpatient treatment, okay? All right. So the modification is granted for inpatient. Anything else for the record in 23-00609, Mr. Brodowitz?
Nothing from the people, Your Honor.
Mr. Abbott?
Nothing, thank you.
All right, and I'm gonna mess up your name. Mr. Knoxell, you're still under subpoena. Thank you for your appearance today, okay?
Thank you.
All right.
Yes, sir. You guys want to-
All right, and then Mr. Brodowitz, just let me know when you're ready on Perry Johnson, okay?
Okay.
All rise.
That's right, Nathaniel left.
Yeah, thank you, Mr. Ring.
Good job.
I've got a very loud voice. I get excited when I get to do it.
Will you shut that door?
Yeah.
Go.
Just need to wait for you out there.
That's
Yeah,
I think you probably went down
I'll
to
be right there.
just
beside
Buchanan.
hers.
Oh.
Bring all you guys.
Sterile.
Stay.
They're not going
I'll
to
put Jeff on this thing. He keeps running away. Okay.
Of course it was.
It's hysterical.
I looked at that exhibit and I was like, the hell am I looking at? Photo of a copy of a photo. Like, what are we doing?
It's a check.
Oh, Jesus. Did I give you any offer? I don't think so. What are you doing, bro? Done for the day, John?
No, I got it at 1 o'clock in 30th Circuit.
Ah,
So, yeah.
how we doing, John?
Tomorrow.
Yeah, I'm over in Ward, covering Ward tomorrow. Yeah, that's what I've heard. Heard we got a draft or whatever it was passed. It's gonna be somewhere in the next 2 to 5 years in the courthouse. Yeah, I don't know. Probably run out somebody, right? It's a trash, yeah. Someone loaded out somebody, right? I'll step in that. Looks was just here. He was getting bagged. Okay.
I say, don't leave again. Did you hear what happened last week? He asked me to go get his, asked me. Oh, man. Asked me to go get his client. So I went down to the jail, got his dude, and I came back up here. He went and started a prelim another quarter. I'm like, what the fuck are you doing?
Who, Milks?
Yeah.
I'll go check. I'm gonna go check on for it.
Chandler. Chandler. John Murray, low PR. Charger, but. I can't with shoes. Donnie went through and take my shoestrings off. Those are adorable. I spent the game some slippers. You. I think you were pink. I think pink just wears you. Yeah. That's the problem with identification. We talked about that. But one of the witnesses you, right? The one where the Flores assault, this is on the pizza case. I'm trying to talk to the prosecutor, see what he wants to do with this one. See what he wants to do. Oh. Morning. Oh, he's still gabbing away. He's a good prosecutor.
Is the sawing and banging company in here?
No, it's Simmons. We just listen to CCW. So this would be the guys here. The witness, sorry, the witness they have. The one guy.
You chat with him without me, you can stay in the hall.
Oh, I don't, wherever you want to be, you be.
I mean, if you're chatting with him, I'll stay in the hall.
Oh, my guy, wait.
No, yeah, if
Oh, no,
if you and him are chatting, I'll stay in the hall, that's what I'm saying.
Yeah, oh, sorry, we're chit chatting.
Okay, yeah.
One witness is the other one is there's a woman witness, and she's always like with the grease trap, that's what she'll say. And there's the guy who is alleging that Flores assaulted her, pointing your guns. The identification comes from the sweatshirt that someone's wearing. The color sweatshirt. There were 4 individuals, 2 people that they actually arrested. One guy was in a black sweatshirt. So they showed pictures of 2 people in a. Let's see what I mean. That person, where that is. I don't know. That's the grease trap. That's the individual. I'm sure this is the individual. Just this is a next structure. There's 4 people. One of them. So. If you can move it. Yeah, right. That's what I'm doing. That's what I'm moving to. Still, everything we talked about still on the table. So we got two hearings, right? One of them, the one where you were arrested on the warrant. We're gonna wait that. Okay, we don't need to do it. This one, we need to do it. Okay, and then we'll just come off the prosecutor. All right. An elephant in this bunch.
Either Bradowitz or Milks?
I'll come to each other.
Okay, thanks. Do you need anything?
To hurry up. Can you do it, please, also?
So we're on the record in docket 23-0090, 23-01063, and then we have 22-00387. Will the parties please introduce themselves for the record, and then we'll decide which cases we're going on first. Mr. Brodowitz.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Mills on behalf of Mr. Perry Johnson, who is present and seated to my right. We will note, Your Honor, that he was written over from Jackson County.
All right. And sir, you are Jeremiah Perry Johnson?
Yes, Your Honor.
All right, thank you. This is the time set for 2 preliminary examinations and a violation of probation. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, after speaking with defense counsel, I believe the parties have agreed to unconditionally waive the right to hold a preliminary examination in both cases. With that, the people would move that both cases be bound over as charged in the complaint to circuit court.
Okay, so that would be on dockets 23-0090, 23-01063, and then on the PA 53 for the violation of probation, which, let's see what the underlying allegation was on that one. How were you going? How was the people going to proceed on that file? That was a probation violation hearing failed to appear for a PV hearing on March 21st. It looks like that's the nature of the probation violation hearing.
The people would seek to dismiss the probation
All
violation,
right.
Your Honor.
It's not a PA 53. I stand corrected. It's a probation violation, failed to appear for a probation violation. Is that your understanding, Mr. Milks? It's an unconditional waiver on the 2 files in the PV. Is the probation violation hearing is going to be dismissed.
It is, Your Honor. I would just like to place for the record, and I apologize for things taking so long. One, it's kind of crazy day, but I was not aware that Mr. Perry Johnson was actually in Jackson County.
Okay.
And that's also what took some time today, is I didn't think he'd appear. He is obviously here. There was also an issue regarding case 23-1063 regarding potential identification issues. We had an opportunity to speak with the prosecutor, speak with the witness as well. I'm sorry, 090. Had an opportunity to speak with the prosecutor regarding that as well as the witness. And so we are comfortable at this time moving the cases up, waiving our right to a preliminary examination in both 1063 as well as 090.
All right. Thank you. So this is an unconditional waiver. Conditional waiver with negotiations to continue. Mr. Milks, may I inquire of your client of his waiver on both files?
Please and thank you.
All right. Sir, so you understand that you have a right to a preliminary examination on files 23-00090 and 23-01063. You have a right to a preliminary examination on both files within 21 days of your date of arraignment. Do you understand that, sir?
Yes, sir.
And I have a waiver of the 21-day rule on both of them for discovery issues. But now it's my understanding you wish to waive your right to a preliminary examination. Is that correct?
Yes, Your Honor.
And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that 1, a crime was committed, and 2, the identity of the person who committed that crime. Do you understand that?
Yes, Your Honor.
You, of course, are represented by Public Defender Stephen Milks, and he would be present to cross-examine any witnesses brought by Mr. Brodowitz or contest any charges brought against you. Do you understand that, sir?
Yes, sir.
Is it your intent today to waive your right to a preliminary examination on docket 23-00090 and 23-01063?
Yes.
Okay. With that understanding, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. Mr. Brodowitz, you also waive your right to a preliminary examination?
Yes, Your Honor.
All right. So the case is bound over as charged on both of those files. And I will give both those files. So you'll have to sign that paperwork on both those files. While you're doing that, he may not because he failed to appear.
Okay.
Yeah. So, yeah, and it was set for hearing today. Yeah. So with that understanding, while you're signing the paperwork on those two files, Mr. Brodowitz, it's your intent today to dismiss the probation violation with the understanding the defendant's incarcerated in Jackson and that the two cases are bound over to circuit court.
Yes, Your Honor.
All right. Any objection, Mr. Milks?
No, thank you, sir.
Okay. There's the PV.
Thanks.
Thanks. All right, Mr. Perry Johnson, you're all set. You get your next day will come from Mr. Milks in circuit court. Your time in district court is done here, all right?
Thank you, Your
All
Honor.
right, thank you. That's all for the record in docket 23-00090 and 23-01063. All right, Mr. Brodowitz, we got through with a half a courtroom, maybe a third of a courtroom.
Well, I asked Wendy if we could make this permanent because it's much cooler in here without the gap.
Yeah, I don't know if we have any choice over that. I like the decor, you know? Yep.
Plus, come on, when you get bored, you get to play the Flores made of love.
Yes. Have a good one, Judge. You too. Take care.
Have a good one.
Wait a second, Brian.
You too.
What?
I said, hang on.
Mr. Milks, always a pleasure.
Sir, the pleasure was all yours.
Absolutely.
I'm teasing. Always is a pleasure.
Oh, folks. Up their exam still began, but I gave court a heads up.
Okay.
They are, they're not done yet.
No, the child victim just got done.
Oh, good, I can go back in now.
Yeah. I discovered mid-sentencing.
Don't step on that.
I know,
You'll stay
I know.
there.
I was smart. I listened to Wendy.
I walked on to see what.
Wow, somebody who actually
Your
listens
client-
to me.
your client
Adam, you
Always
have
listen
all
to
the
you,
stuff.
Wendy.
Ha!
Yeah,
That's fair.
yeah, your client just about lost it.
No, I discovered mid-sentencing